This is Earl White, real estate attorney. This is a video about how to add a spouse to a deed in New Jersey. We assist residential homeowners, investors, putting spouses on deeds on a regular basis. Now, before you would take that step, there are specific legal considerations, financial considerations, inheritance considerations that you should be weighing before transferring it. And then as part of the transfer, there are specific steps that you need to take. And we're going to go over all those considerations and the specific steps that you need to take to make sure you know how to transfer a deed and it's also a good fit for your situation. First, let's discuss the reasons that you may wish to add your spouse to a real estate deed. The first reason that it makes sense in many situations is that if it's just one person on title, then the decision-making authority is limited to that one person. By adding a spouse to the deed, now both members of the couple can take legal action relating to the property, whether that's taxes, bank accounts, refinancing. Both people who are on title, it makes it easier for parties to make decisions as opposed to always falling onto one person who may even not be the regular party handling the property. The second reason that people often add their spouse to the deed is that it assists in the inheritance process if one of the members of the marriage dies. If you don't have your spouse on the deed, then the property passes via general inheritance laws or if there was a will. Now, if you want to put the spouse on the deed at that point, it doesn't happen automatically anymore. You will have to file to become an executor or an administrator of the estate of the spouse on title, and then that was how you will then have authority to transfer the property over to the other spouse. If you put the spouse on the deed in advance of that, then you don't have to go through that whole you may still have to go through it for other reasons, but you will not have to deal with that for purposes of transferring title. The final reason that individuals may want to join in title their spouses is for emotional reasons. If it's a married couple, then one party may be concerned that they're contributing equally to the maintenance of the property and the financials of the property, but they're not on the title. And that does raise concerns. If there's a divorce, it does raise concerns. If there's a sale, that the party not on title could essentially be frozen or cut out of the process because there's no record of them being part of it. Now, New Jersey does have marital rights, and if it is a marital residence, then both individuals on title should sign off to clear title. However, the current owner, when we're running a title search, we will only find the current owner on the deed, and we count on them to be honest about their marital status in order for us to make sure clear title is passed, but they might not be honest. If the family member or spouse is not on the deed, that could be concerning. And so either for the emotional reasons and fear that they can be not part of the sale process, at least not in writing, that's another reason to add a spouse to the deed. Now let's discuss why a married couple would not want to add a spouse to a real estate deed. In my opinion, the most significant reason to not add your spouse to the deed is if you expect your spouse to have any legal problems. If your spouse, while they're on title, has a court judgment issued against them, then that now becomes a lien on the property. And therefore, if you wish to sell, transfer title, refinance, that when they run the name searches, they're going to find the spouse, they're going to search for court cases and judgments on their name, and they're going to find it, and then it will have to be paid off at the closing. If you just leave one spouse without adding the other, then you don't have to worry about an extra person coming on title and causing a legal problem. The only judgments in court cases that will be relevant to the property will be the spouse on title. The second reason you may not want to add your spouse to title is that if only one party is contributing to the maintenance of the property. This can become more significant for a property that was purchased before the marriage or property that's investment property that maybe have been purchased during the marriage, but only one person is investing in real estate. You could at least make an argument that if one person has acquired it on their own and has handled the upkeep of the property financially and all other issues, particularly an investment property where it's never been the marital residence, then there's the argument that person should have enhanced entitlement to the property. Again, that's an equitable argument and something. If it was a divorce, then the judge would have to hear that out. But that is a reason that parties may not put the other spouse in when we just want one person to be the key decision maker in the upkeep and transfers of the property. Now, I often read on the internet or hear considerations that before adding your spouse to the title, to the deed, that you should consult with your lender and ask them for permission. But this is not a requirement for conventional mortgages. So what we're talking about here, when people say, oh, you have to get the lender's permission, is what's called a due on sale clause. The conventional mortgages always have language that says if the property transfers, or if the ownership transfers, then they can call the loan due, which means that the immediate balance they can call due. And if you don't pay the immediate balance, then they can foreclose on the current owner. As of when I'm recording this video, September 2025, they always have a sentence in that due on sale clause, which specifically says, unless prohibited by applicable law. And therefore, the question is then, is there any applicable law that would stop the lender from calling the loan due because the transfer is to your spouse, which there is. And I will give the name of it, St. Garn Act, 12 U.S. Code, Section 1701 J3, subsection 3. This prohibits the lender from enforcing the due on sale clause when transferring to the spouse. So that language is in the federal law. Therefore, the due on sale clause is prohibited by the applicable federal law. And therefore, you do not need lender permission to make this transfer. In fact, I wouldn't even recommend it personally to you, because if you start asking for permission to conduct this deed transfer, then you get people at these companies that don't understand the law. And then they start saying, we're not going to allow it. We're going to prohibit it. And now you've created this problem, right? When you just had the law on your side, did not need permission. And then you created this Pandora's box by trying to get permission. So I don't think it's a requirement to consult with a lender as long as it's a standard conventional loan, or really any loans, because the federal law that we cited doesn't just apply to conventional, but to any due on sale clause. It may be good to look at the language of your mortgage, but in terms of jumping to your lender and telling them that you want to add your spouse to the deed, you're just largely creating problems that don't need to exist. Now let's go over step-by-step process of adding your spouse to the deed. Step one is consult with or hire an attorney to prepare the deed. If you are not, you can prepare your own deed for yourself. However, if this is coming through a child or family member that's assisting the parents, that relationship in New Jersey, the creation of the deed is the practice of law, and the courts have stated this. So with limited exception, yes, the owner can prepare their own deed for this, but if the third party, they cannot prepare their own deed. So I'd recommend consulting with an attorney to make sure, like the considerations we were talking about before, to make sure that you've thought through those. And then also make sure if you're not the owner doing the transfer, then that you don't illegally practice law in New Jersey. Let's just say that you were considering hiring an attorney. The next step is to prepare the deed and supporting documents. So the deed has very specific language you need to include. Grantor, the person transferring ownership; the grantee, the person receiving ownership. In this case, you would specify the grantee, the new people joining title, as both spouses, since they are both going to be the owners. And you also make sure here it's a key fact that last names maybe have changed to some extent. For example, if there was a spouse on title, like a wife, and then she's transferring it over to join her husband on title, then she may have changed her last name as part of the process. So you want to update those names as part of the deed. Make sure your lot and block and legal description are proper so that the deed doesn't get bounced and waste time on incorrect recordings or get recorded on the wrong property, which would be a serious problem if that were to happen. Next, besides the deed, you have a get rep form in New Jersey. This would be a get rep 3 form where you're basically stating the reason that there's no tax withholdings, because if none of those apply, there is a tax withholding. But for this, you would have an applicable box that consideration, quote unquote consideration, is less than $1,000 just because it's an inter-transfer for no money's exchanging hands. You also have an affidavit of consideration form to fill in, where now we have a person is notarizing that form, and they have to notarize the deed too. So you're notarizing the forms before a notary or before an attorney in New Jersey. And that will have to attest to the circumstances with the mortgage, the amount of the consideration. Like I said, it's probably be $1 RUP will specify, and other information about the property, such as the ownership addresses and the new addresses of owners. So that will be formally then in the affidavit of consideration. Okay, so next, once documents have been fully drafted and prepared, next step is to have them notarized. Now, once they're notarized, the documents need to be taken and submitted to the county. The options there are e-recording, or you can do a drop-off paper, or you could mail the papers to the county. So those are 3 ways to do it. I believe personally e-recording is the best method because you don't have to worry about documents getting lost in the mail, delayed in the mail. And believe it or not, that can happen where the documents get lost like any other mailing, and then you're waiting all this time to find out. So e-recording, basically docs are notarized, scan them in, submit them, you still have the docs, and then everything will get recorded. And that is the smoothest process to have this done. So I hope this video was helpful. If you are a homeowner or own investment property and need help making a transfer on title, whether it be to add a spouse or some other reason, give our law firm a call. This is one of our core practice areas that we do on an everyday basis.